Part 1. The Sovereignty of Parliament. Chapter 1. The Nature of Parliamentary Sovereignty. The sovereignty of Parliament is, from a legal point of view, the dominant characteristic of our political institutions. My aim in this chapter is, in the first place, to explain the nature of parliamentary sovereignty and to show that its existence is a legal fact, fully recognised by the law of England. In the next place, to prove that none of the alleged legal limitations on the sovereignty of Parliament have any existence, and lastly, to state and meet certain speculative difficulties which hinder the ready admission of the doctrine that Parliament is, under the British Constitution, an absolutely sovereign legislature. Nature of parliamentary sovereignty. Parliament means, in the mouth of a lawyer, though the word has often a different sense in ordinary conversation, the King, the House of Lords, and the House of Commons. These three bodies acting together may be aptly described as the King in Parliament and constitute Parliament. The principle of parliamentary sovereignty means neither more nor less than this, namely that Parliament thus defined has, under the English Constitution, the right to make or unmake any law whatever, and further, that no person or body is recognised by the law of England as having a right to override or set aside the legislation of Parliament. A law may, for our present purpose, be defined as any rule which will be enforced by the courts. The principle, then, of parliamentary sovereignty may, looked at from its positive side, be thus described: any Act of Parliament, or any part of an Act of Parliament, which makes a new law, or repeals or modifies an existing law, will be obeyed by the courts. The same principle, looked at from its negative side, may be thus stated: there is no person or body of persons who can, under the English Constitution, make rules which override or derogate from an Act of Parliament, or which, to express the same thing in other words, will be enforced by the courts in contravention of an Act of Parliament. Some apparent exceptions to this rule no doubt suggest themselves, but these apparent exceptions, as where, for example, the judges of the High Court of Justice make rules of court repealing parliamentary enactments, are resolvable into cases in which Parliament either directly or indirectly sanctions subordinate legislation. This is not the place for entering into any details as to the nature of judicial legislation. The matter is mentioned here only in order to remove an obvious difficulty which might present itself to some students. It will be necessary in the course of these lectures to say a good deal more about parliamentary sovereignty, but, for the present, the above rough description of its nature may suffice. The important thing is to make clear that the doctrine of parliamentary sovereignty is, both on its positive and on its negative side, fully recognised by the law of England. Unlimited legislative authority of Parliament. The classical passage on this subject is the following extract from Blackstone's Commentaries. Sir Edward Coke says, quote, "The power and jurisdiction of Parliament is so transcendent and absolute that it cannot be confined, either of causes or persons, within any bounds. And of this High Court, he adds, it may be truly said,
Si antiquitatem spectes est vetustissima, si dignitat est honoratissima, si jurisdiction est capicissima.
It hath sovereign and uncontrollable authority in the making, confirming, enlarging, restraining, abrogating, repealing, reviving, and expounding of laws, concerning matters of all possible denominations, ecclesiastical or temporal, civil, military, maritime, or criminal, this being the place where that absolute despotic power, which must in all governments reside somewhere, is entrusted by the constitution of these kingdoms. All mischiefs and grievances, operations and remedies that transcend the ordinary course of the laws are within the reach of this extraordinary tribunal. It can regulate or new model the succession to the crown, as was done in the reign of Henry VIII and William III. It can alter the established religion of the land, as was done in a variety of instances in the reigns of King Henry VIII and his three children. It can change and create afresh even the constitution of the kingdom and of parliaments themselves, as was done by the Act of Union, and the several statutes for triennial and septennial elections. It can, in short, do everything that is not naturally impossible, and therefore some have not scrupled to call its power, by a figure rather too bold, the omnipotence of Parliament. True it is that what the Parliament doth, no authority upon earth can undo, so that it is a matter most essential to the liberties of this kingdom, that such members be delegated to this important trust, as are most eminent for their probity, their fortitude, and their knowledge. For it was a known apothegm of the great Lord Treasurer Burleigh, that England could never be ruined but by a Parliament, and, as Sir Matthew Hale observes, this being the highest and greatest court over which none other can have jurisdiction in the kingdom, if by any means a misgovernment should any way fall upon it, the subject of this kingdom are left without all manner of remedy. To the same purpose the President Montesquieu, though I trust too hastily, presages that as Rome, Sparta, and Carthage have lost their liberty and perished, so the Constitution of England will in time lose its liberty, will perish. It will perish whenever the legislative power shall become more corrupt than the executive. End quote. Delhomme has summed up the matter in a grotesque expression which has become almost proverbial. It is a fundamental principle with English lawyers that Parliament can do everything but make a woman a man and man a woman. This supreme legislative authority of Parliament is shown historically in a large number of instances. The descent of the Crown was varied and finally fixed under the Act of Settlement 12 and 13 William III c2. The King occupies the throne under a parliamentary title. His claim to reign depends upon and is the result of a statute. This is a proposition which, at the present day, no one is inclined either to maintain or to dispute, but a glance at the statute book shows that not much more than 200 years ago Parliament had to insist strenuously upon the principle of its own lawful supremacy. The first section of 6 Ann c7 enacts, inter alia, quote, that if any person or persons shall maliciously, advisedly, and directly, by writing or printing, maintain and affirm that our sovereign lady the Queen that now is not the lawful and rightful Queen of these realms, or that the pretended Prince of Wales, who now styles himself King of Great Britain, or King of England by the name of James III, or King of Scotland by the name of James VIII, hath any right or title to the crown of these realms, or that any other person or persons hath or have any right or title to the same, otherwise than according to an Act of Parliament made in England in the first year of the reign of their late Majesties King William and Queen Mary, of ever blessed and glorious memory intituled, an Act declaring the rights and liberties of the subject, and settling the succession of the crown, and one other Act made in England in the 12th year of the reign of his said late Majesty King William III, intituled, an Act for the further limitation of the crown, and better securing the rights and liberties of the subject, and the Acts lately made in England and Scotland mutually for the union of the two kingdoms, or that the kings or queens of this realm, with and by the authority of Parliament, are not able to make laws and statutes of sufficient force and validity to limit and bind the crown, and the descent, limitation, inheritance, and government thereof, every such person or persons shall be guilty of high treason, and being thereof lawfully convicted, shall be adjudged traitors, and shall suffer pains of death, and all losses and forfeitures, as in cases of high treason. End quote. The Acts of Union, to one of which Blackstone calls attention, afforded a remarkable example of the exertion of parliamentary authority, but there is no single statute which is more significant either as to the theory or as to the practical working of the Constitution than the Septennial Act. The circumstances of its enactment and the nature of the Act itself merit therefore special attention. In 1716, the duration of Parliament was under an Act of 1694 limited to 3 years, and a general election could not be deferred beyond 1717. The King and the Ministry were convinced, and with reason, that an appeal to the electors, many of whom were Jacobites, might be perilous not only to the Ministry but to the tranquillity of the state. The Parliament then sitting, therefore, was induced by the Ministry to pass the Septennial Act, by which the legal duration of Parliament was extended from 3 to 7 years, and the powers of the then existing House of Commons were in effect prolonged for 4 years beyond the time for which the House was elected. This was a much stronger proceeding than passing, say, an act which enabled future parliaments to continue in existence without the necessity for a general election during 7 instead of during 3 years. The statute was justified by consideration of statesmanship and expediency. This justification of the Septennial Act must seem to every sensible man so ample that it is with some surprise that one reads in writers so fair and judicious as Hallam or Lord Stanhope attempts to minimise the importance of this supreme display of legislative authority. Hallam writes, quote, "Nothing can be more extravagant than what is sometimes confidently pretended by the ignorant, that the legislature exceeded its rights by this enactment, or, if that cannot legally be advanced, that it at least violated the trust of the people, and broke in upon the ancient constitution." End quote. This remark he bases on the ground that, quote, "the law for triennial parliaments was of little more than 20 years' continuance. It was an experiment which, as was argued, had proved unsuccessful. It was subject, like every other law, to be repealed entirely or to be modified at discretion." End quote. Lord Stanhope says, quote, "We may cast aside the foolish idea that the Parliament overstepped its legitimate authority in prolonging its existence, an idea which was indeed urged by party spirit at the time, and which may still sometimes pass current in harangues to heated multitudes, but which has been treated with utter contempt by the best constitutional writers." End quote. These remarks miss the real point of the attack on the Septennial Act, and also conceal the constitutional importance of the statute. The 31 peers who protested against the bill because, among other grounds, quote, "It is agreed that the House of Commons must be chosen by the people, and when so chosen they are truly the representatives of the people, which they cannot be so properly said to be, when continued for a longer time than that for which they were chosen, for after that time they are chosen by the Parliament, and not the people, who are thereby deprived of the only remedy which they have against those who either do not understand or through corruption do wilfully betray the trust reposed in them, which remedy is, to choose better men in their places." End quote. Hit exactly the theoretical objection to it. The peculiarity of the Act was not that it changed the legal duration of Parliament or repealed the Triennial Act. The mere passing of a Septennial Act in 1716 was not, and would never have been thought to be, anything more startling or open to graver censure than the passing of a Triennial Act in 1694. What was startling was that an existing Parliament of its own authority prolonged its own legal existence. Nor can the argument used by Priestley, and in effect by the protesting peers, quote, that septennial parliaments were at first a direct usurpation of the rights of the people, for by the same authority that one parliament prolonged their own power to 7 years, they might have continued it to twice 7, or like the Parliament of 1641, have made it perpetual, end quote, be treated as a blunder grounded simply on the ignorant assumption that the Septennial Act prolonged the original duration of Parliament. The contention of Priestley and others was in substance that members elected to serve for 3 years were constitutionally, so far at least as the delegates or agents of their constituents, that they could not, without an inroad on the Constitution, extend their own authority beyond the period for which it was conferred upon them by their principals, i.e. the electors. There are countries, and notably the United States, where an act like the Septennial Act would be held legally invalid. No modern English Parliament would, for the sake of keeping a government or party in office, venture to pass, say, a decennial act, and thus prolong its own duration. The contention, therefore, that Walpole and his followers, in passing the Septennial Act, violated the understandings of the Constitution, has on the face of it nothing absurd. Parliament made illegal, though unprecedented, use of its powers. To underrate this exertion of authority is to deprive the Septennial Act of its true constitutional importance. That act proves to a demonstration that, in a legal point of view, Parliament is neither the agent of the electors, nor in any sense a trustee for its constituents. It is legally the sovereign legislative power in the state, and the Septennial Act is at once the result and the standing proof of such parliamentary sovereignty. Hitherto, we have looked at Parliament as legally omnipotent in regard to public rights. Let us now consider the position of Parliament in regard to those private rights which are in civilised states justly held specially secure or sacred. Coke, it should be noted, particularly chooses interference with private rights as specimens of parliamentary authority. Quote, yet some examples are desired. Daughters and heirs apparent of a man or woman may by Act of Parliament inherit during the life of the ancestor. It may adjudge an infant or minor of full age. To attaint a man of treason after his death. To naturalise a mere alien and make him a subject born. It may bastard a child that by law is legitimate, viz. Begotten by an adulterer, the husband being within the 4 seas. To legitimate one that is illegitimate, and born before marriage absolutely, and to legitimate secundum quid, but not simpliciter. End quote. Coke is judicious in his choice of instances. Interference with public rights is at bottom a less striking exhibition of absolute power than is the interference with the far more important rights of individuals. A ruler who might think nothing of overthrowing the constitution of his country would in all probability hesitate a long time before he touched the property or interfered with the contracts of private persons. Parliament, however, habitually interferes for the public advantage with private rights. Indeed, such interference has now, greatly to the benefit of the community, become so much a matter of course as hardly to excite remark, and few persons reflect what a sign this interference is of the supremacy of Parliament. The statute book teems with acts under which Parliament gives privileges or rights to particular persons, or imposes particular duties or liabilities upon other persons. This is of course the case with every railway act, but no one will realise the full action, generally the very beneficial action, of parliamentary sovereignty, who does not look through a volume or two of what are called local and private acts. These acts are just as much acts of Parliament as any statute of the realm. They deal with every kind of topic, as with railways, harbours, docks, the settlement of private estates, and the like. To these you should add acts such as those which declare valid marriages which, owing to some mistake of form or otherwise, have not been properly celebrated, and acts, common enough at one time but now rarely passed, for the divorce of married persons. One further class of statutes deserve in this connection more notice than they have received. These are Acts of Indemnity. An Act of Indemnity is a statute, the object of which is to make legal transactions which, when they took place, were illegal, or to free individuals to whom the statute applies from liability for having broken the law. Enactments of this kind were annually passed with almost unbroken regularity for more than a century, 1727 to 1828, to free dissenters from penalties for having accepted municipal offices without duly qualifying themselves by taking the sacrament according to the rites of the Church of England. To the subject of Acts of Indemnity, however, we shall return in a later chapter. The point to be now noted is that such enactments being, as it were, the legalisation of illegality, are the highest exertion and crowning proof of sovereign power. So far, the sovereignty of Parliament from its positive side. Let us now look at the same doctrine from its negative aspect.